I wanted to record this video because I'm writing a fairly complex post dealing with a couple of disclosures that happened in the last few days. And I want to explain how they all relate to questions of Elon Musk's agency. And by that, I mean in both senses. Uh, these three different legal theories, a total of at least 5 cases, are beginning to coalesce, are beginning to pincer around Elon Musk on questions of how much he has been personally responsible for with Doge and whether Doge is an agency under a variety of laws. There are 3 theories, as I said, that are at issue. One is simple. One is FOIA. So months ago, Crew, which everyone I think knows as a transparency organization, sent a FOIA to the Office of Management and Budget about Doge. And they made the mistake of accepting that and of granting accelerated treatment of that FOIA. Since then, Crew has been FOIAing to just be able to get basic information about Doge. This wouldn't be an important lawsuit per se, except that the White House is not subject to FOIA. Agencies are. So like OMB is, the White House is not. And one of the reasons, well, let me take a step back. When Elon Musk, after the election's like, we're going to do Doge. And at first, it wasn't clear how they were going to do it. Remember that Vivek Ramaswamy was supposed to be involved. They were going to make substantive changes. And then as a bunch of people had lawsuits prepared on January 20th, arguing that Doge violated disclosure requirements to Congress, Trump surprised everyone and he said, Doge is going to be USDS, U.S. Digital Services. And basically what they did, and this was, at the time, it looked like bureaucratically brilliant. They took an existing entity created under Obama, which does good or did good things, and made it Doge. And for the short term, that allowed Doge to not have to go to Congress and say, we're creating a new agency. They basically just repurposed USDS. So that was brilliant in the short term because it gave USDS and Doge cover as being a White House entity. So they didn't have to go to Congress. They didn't have to be subject to FOIA. They didn't have to be subject to congressional review. Seemed brilliant. And then 3 different lawsuits came about, and we're at a point now where DOJ is scrambling and making wildly conflicting claims to different judges. And not only are we beginning to get our judges beginning to grant some transparency on Doge, which in and of itself is going to be important, but they are getting closer to treating DOJ's conflicting claims as unreliable, which is important from a legal standpoint, meaning like normally when DOJ says something, you have to take their word at it because it's called presumption of regularity. But DOJ has made so many conflicting claims about what Doge is that judges are getting closer and closer to saying bullshit. Doesn't, like you've already shot your wad on these claims and you can't be treated with credibility. And then finally, they get closer to what may be the really important prize, which is what's called an appointments clause challenge to Doge in general. Yesterday, a Maryland judge, Judge Theodore Twang, granted an injunction for 26 USAID contractors so that Doge had to reverse the things they have done to USAID. I think that order, while really important, will have limited value because he basically said, you only sued Elon Musk, and therefore he only has to reverse the stuff that Elon Musk did, which amount to shutting down the building and shutting down the website. Whereas the stuff that Marco Rubio or Pete Marocco were involved with, I can't reverse that because they are not part of this lawsuit. And basically what's going to happen is Marco Rubio is going to give Doge permission to do all the things they've already done, like shut USAID. But still, this theory, the appointments clause theory, is the one that the Supreme Court may uphold. It's the one, it basically says if you are an agency, then Congress has to have created you, and you need to get Senate approval to be the administrator of that agency. And this is the theory, for example, that Judge Aileen Cannon used to throw out the Jack Smith investigation into Donald Trump. This is a theory that Supreme Court really loves. It's a theory that elsewhere is going to work against plaintiffs when Trump has been firing people, but in this case may actually work for plaintiffs to get the Supreme Court to say, yeah, you can't dismantle entire agencies without congressional approval. So, taking a bunch of steps back, as I said, Cruz sued right away. OMB was stupid enough to accept the FOIA, and Crew has been arguing based on things that Elon keeps claiming, like, this weekend I put USAID through the wood chipper. That's one that shows up in all of these court filings. Crew has been arguing that Doge is an agency. And some weeks ago, Judge Christopher Cooper granted Crew's FOIA request. Basically said, not only we're going to let you do a FOIA request, but we're going to do this on some accelerated process so that we can move forward with the lawsuit. So that's one thing. Fairly low risk. You're not going to shut down Doge on a FOIA. You're going to get some information about Doge, but you're going to get some visibility on Doge. Now, I'm pretty sure that DOJ is going to appeal that, but it is a simple FOIA thing, and you're going to be before the DC Circuit with claims like the wood chipper one. An interim one, and this is what's super interesting, and this is where stuff got interesting yesterday, is a bunch of unions are suing. It started with Department of Labor. When Doge came for Department of Labor, they're like, whoa, we need a Department of Labor because if we can't make confidential complaints to Department of Labor, say about Tesla plants in Texas, then our protection under the Department of Labor goes away. And then they've since added CFPB and HHS. And that lawsuit started as a privacy lawsuit, right? And there have been a bunch of efforts to go after Doge for all of the data collection they're doing under a Privacy Act theory. And so far they've been unsuccessful because you can only get Privacy Act help if stuff is being shared outside official business. I'll decide it that way. And especially you get even less protection if data about you is shared if you're a government employee. So those, like, there have been a bunch of Privacy Act challenges to Doge's information sharing. But this unions one is different for two reasons. One is that these unions are making Elon's conflicts an issue, as I mentioned, right? So you've got Tesla, you've got OSHA. Tesla's already been found to have been involved in killing a Tesla employee worker in Texas. And the unions are arguing like, look, Elon can't get access to this because he's an adverse party. There are trade secrets he's getting access to. So one thing they did was to use his conflicts, which, if this goes forward, will be very interesting. But the other thing they did is after their first bid for a restraining order got thrown out, they came back and they said, under the Economy Act of 1932, these entities, these Doge people, can only get information under the Privacy Act if Doge is an agency. And their second bid to get a restraining order still failed. But Judge Bates, who I described yesterday as kind of a squish judge, I have never been a particular fan of him, but when he denied their request for a restraining order last month, he basically said, this question about what is an agency under the Economy Act is an interesting one, and I see that Doge is trying to have it both ways. Doge doesn't want to be an agency because if they are, they're subject to the law of FOIA, and they're subject to the Appointments Clause. They're arguing sort of that they're in a middle ground, But if they're not an agency or some kind of entity that is allowed to get this sharing, then they can't have the data. They can't have the data. And so he said, let's move to the next stage of the lawsuit. And in the next stage of the lawsuit, the unions were like, hey, you said that we need to learn more about whether Doge is an agency or not. Let's get discovery on that. And so on March 10th, I think it was, he granted them discovery. And then, or no, it was in February. He granted, it was the end of February after, this is important, after Amy Gleason had already been rolled out as the administrator of Doge. He granted discovery, and then the agencies very quickly tried to change the status of the Doge people who were inside their agencies, including, we discovered yesterday, Amy Gleason. So days after, on February 25th, the government claimed Amy Gleason was Amy Gleason and not Elon Musk was the administrator of Doge. On March 4th, they made her an employee of HHS. So Amy Gleason, supposed to be running Doge, now an employee of HHS, which is where her actual expertise is. And so the government tried to change the status of these employees, and in the process made Amy Gleason an employee of HHS. Meanwhile, they're trying to get Judge Cooper to reverse his order in the Crew case, on the FOIA case. And 6 days after Amy Gleason filed a declaration saying she was an employee of HHS, she filed a declaration in the Crew suit saying, I'm a full-time administrator of Doge. Sharply conflicting statements, both given under oath. Now, these matter because if Amy Gleason is not the administrator of Doge and Elon is, then Elon is going to be the one that needs to go before Congress and get congressional approval, Senate approval. As I said, a Maryland judge yesterday granted a preliminary injunction on this theory, but of interest, a couple of days earlier, I think March 12th, Tanya Chutkin, who has 2 of these appointments clause cases before her. One is called New Mexico. It's a bunch of Democratic attorneys general, and the other one is called Japanese American. It's a bunch of nonprofits who have interests in a bunch of agencies like the National Park Service. And she may actually consolidate them, but she granted the attorneys general discovery. So they now have a limited amount of time to go to Doge and say, prove to me that Elon Musk is not your administrator. Prove to me that Amy Gleason is not your administrator. And the reason this is matter, and this is the simple message that I want to take away, is you've got agencies who are subject to FOIA. And one judge has already said Doge is an agency subject to FOIA. You've got Privacy Act, which does not permit non-agency, and Doge is claiming they're sort of in between, but does not permit non-agency employees from accessing all this data that Doge has accessed. In that case, Judge Bates seems really inclined to rule that Doge is an agency as well, which says there's no Privacy Act violation, but says you've got Doge being ruled an agency over and over again. And then you've got Judge Truong yesterday who said, they sure looks like an agency to me. And Judge Chutkin moving closer to ruling that Doge is an agency there. Again, this matters most of all. The transparency is important, but it matters most of all because in a ruling that Doge unlawfully closed down a bunch of agencies is most likely to be sustained, in my opinion, under an appointments clause. Because again, Supreme Court likes that theory and it makes a lot of sense. And so in the interim, what we've got is we're beginning to get more transparency on what Doge is, but really importantly, we've now got wildly conflicting sworn declarations from the woman who is supposed to be in charge of Doge. And you're seeing those kinds of conflicting statements snowball. And I think that that gives the judges a lot more leeway to treat Doge as just a garbage liar fraud entity. So that's why it's important. Is Elon Musk an agent, an agency? And if so, all of a sudden you have laws that you can use against him, not Privacy Act, but you can FOIA him and you can go to the Supreme Court with an Appointments Act clause.